the Peter Obi's petition, though, did not challenge the educational qualification of the APC candidate, but they challenged double nomination. They also challenged the issue of forfeiture of $460,000. And then what the tribunal, Peter Obi, Atiku on the other hand, also claimed that they won. Then Peter Obi talked about Abuja 25%, that not having won 25% in Abuja ought not to have been declared, and that at best the election would have been declared inconclusive. So Atiku the same thing, claiming that he won also, and Atiku also claiming a qualification, double nomination, and the FCT, and then the forfeiture. The first and foremost, what the tribunal simply did was, tribunal looked at both petition and the respondents' answers and said, okay, the witnesses, there were preliminary objections raised by the respondent that, look, this witnesses' statement cannot go in because they were filed outside the 21 days. The tribunal looked at them and said, oh, for the Peter Obi's petition, 10 witness statements were filed outside 21 days. And so to that extent, they did not meet the requirement of the law. Also, the fact that the law says that this petition shall be filed with witness deposition and document to be relied on. The tribunal, funny enough, the tribunal now quoted the dictum or the forward written by PDP's lawyer to say, this is your own statement. You said that every election petition must be accompanied by witness statement and document to be relied on. A failure to do so is fatal. We believe you, but you can't come and argue the opposite here. So having looked at that, they now also went further to say, okay, these witnesses that are coming to testify, okay, yes, you say their witness statements were filed out of time. The expert witness, are you truly coming as an expert? If you are coming as an expert, which document are you coming to tender? This document was made by somebody else. You cannot be cross-examined. It is an elementary principle of law that you cannot be cross-examined on the document you did not make. And you're coming, and that document also do not speak to the general issues, especially when the document is disputed. And the court said, not having made that document, you cannot come and then you came after the petition was filed. You can't be a subpoena witness because you were available to the party all of this while. So why didn't they make you a witness? Why did they wait after 21 days? They are now bringing you. That is overreaching the other party. So you cannot. For those that do not know, say, oh, the court used sentiment. Then on the issue of the, the AU and EU report, when we know, Kenneth Osuwa also as a lawyer knows, we both had the same former boss. All of these are elementary law that we know. The maker, if you are talking about a report, that you want to rely on the report that can be cross-examined, the maker of that report must be the one to tender the report. It is not a public document that you say, okay, a CTC will suffice. It is, they say you made a report. You are bringing the report without bringing the maker that can be cross-examined. And the court said, well, you not being the maker of this document, you can't tender it. You can't even be cross-examined on it. Everything, you can't just come and dump document on us. What would be the probative value of the evidence that we're going to attach to it? So we cannot accept it. The court also now looked at the issue of Abuja and said, looking at section 299 of the 1999 Constitution, it says, for the purpose of this Constitution, the FCT shall be regarded as a state. And to that extent, the National Assembly and the President shall make laws for the President, for the states, for the FCT, and administrative decisions shall be taken by the President. So, but in the event that you are interpreting this Constitution, you shall interpret it to be a state. It didn't say, the law, the Constitution didn't now say, oh, because it didn't have a governor or because it doesn't have House of Assembly, it is not a state. The Constitution says if you are interpreting this law, excuse me, We shall take it as a state. And so to that extent, the court said, that is what the Constitution says. And then the court now went further to say, there are no special votes. If you say FCT has special votes, are you now saying that if somebody won 100% in 36 states of the Federation without winning 25% in Abuja, that person cannot be declared as winner of an election? That is not the intent of the drafters of the Constitution. And then the court, like I said, also look at the issue of double nomination. Being a court of appeal, and my brother Kenneth has said, a court of appeal is lower in rank to a Supreme Court. A court of appeal cannot sit down on appeal or relitigate a matter where the Supreme Court has made a pronouncement on the position of things, especially when it concerns the parties. And they said, well, on this issue of double nomination, they quoted the dictum of Okoro and the dictum of, what's the name of this other judge, and said, these people had chewed on this issue, brought out the nomination date, and that resignation took effect from the provision of the Constitution the day the man who was nominated as a senator tendered his resignation to his party, and that the party had a window of 90 days within which to forward a request to the national, to INEC, that it is not when the party forward a request to INEC that resignation took place, but when the person who is involved tendered a resignation to his party. And that this member was nominated as running mate 4 days after he tendered his resignation as a candidate of the senatorial candidate to his party. The Supreme Court had dealt with that, and that was what the position of the Supreme Court. And so to that extent, we cannot say that this man, there was double nomination. On the issue of IREV, Supreme Court, the court said, well, we don't make law. Our own is to interpret the law. If Section 60 says INEC in transmitting election results shall have recourse to Form EC8A, and that Form EC8A, if you are not able to transmit it electronically, it shall be at the once it has been signed and distributed, the transmission shall be as recommended by INEC. INEC in its guideline recommended electronic transmission. And the same INEC, it is not another person now. If it is a different institution, that is where you now say, no, a different institution cannot come to say that INEC has made a recommendation. That institution or NCC or DSS or the police now say, no, INEC must not. Once that happens, that is when you say that INEC guideline had been violated by another institution. But in this case, it is the same INEC that came and said, well, the requirement we made, we said we will transmit electronically. We are not able to transmit electronically. We have accredited. The law says you must accredit with a device, an electronic device. But we cannot transmit because we have force majeure. So we are going to use another method. Do you know that throughout the entire gamut of the proceedings, you say the parties claim that they have witnesses and they have what do you call it, a polling unit agent across the 175,000 polling, 176,000 polling units. Not one person from either of the polling units was called by any of the party to say, come on, not one agent at all. And so the court said, failure to call agent means that if you call them, that is the presumption against you. That failure to call them means that if you call them, the evidence I'm going to give will be against you. That is why you didn't call them, even though you said you were going to call them. Secondly, the document and the video you said you were going to provide. Failure to provide them is a presumption of law also that if you provide them, they will be against you. That was why you did not provide them. All of these were dealt with.
Mr. Libourous